Due to time constraints, I am only going to give a very short version of our testimony, which was submitted in writing previously. And I want to cut to the chase and address what I consider to be the 5 critical issues. The first issue is, does New York's department-based system lead to regional disparities in the implementation of discipline? And the answer is obviously it does. The question is, how significant is that, and what should we do about it? NYCL believes that there should be a move to procedural uniformity, but that move to procedural uniformity should be guided by the geographic and population differences in the departments. The first and second departments are densely populated and relatively small in comparison to the third and fourth departments, and we see some of the departmental differences as a result of these geographic and population differences. We have an extensive report on these issues on our website should you require any further detail. We also believe that there should be a move to uniformity on the issues of letters of caution, letters of education, and letters of admonition. Whatever policy there is should be the same in all 4 departments, and we would urge the Commission to move in that direction. Having said that, we concur with the first witnesses who pointed out that there is extensive precedential value in the departmental decisions on specific fact-based cases, and for this reason, we reject any move to mandatory guidelines or any kind of sentencing guidelines. The second question is a statewide system desirable? And in our view, the answer is no. We believe a statewide system would be more costly and introduce more delays. We also think a statewide system would undercut the precedential value of the existing fact-based decisions. And I cannot emphasize enough to you our view that these decisions are frequently very fact-based, and in that regard, I would echo Mrs. Scalise's testimony on that point. The third question that's on everyone's mind is how the disciplinary committees can achieve dispositions more quickly. Well, it seems to me that there are 2 simple answers. One is more resources, and the second is plea bargaining. Now, there has not been much discussion of that, but maybe there should be. In the first department, there are cases where the parties come quickly to the conclusion of what should happen, and then they go through a 3-stage process to finally reach the decision that they've already figured out in advance. It is not something that's been discussed, but it is something that should be considered. The fourth issue is the question of public disclosure of the process. We oppose any disclosure prior to the imposition of formal discipline. Any other result would undercut the letters of education and caution that are issued in some of the departments. We also think on balance, balancing the public interest and the interest of the attorneys, that is the right balance, and it is currently the statutory balance. Finally, an issue that has not gotten enough attention, maybe because it doesn't really belong here, and that is the question of discovery for respondent attorneys. We support discovery for respondent attorneys. We have endorsed the 6 recommendations of the New York State Committee on Discipline. That concludes my oral statement.
Thank you. Yes.
One focused question I wanted to ask you about being within the first department generally. If we move towards a uniformity of process, one of the issues on the table with that would be how formal proceedings are conducted statewide. Given that the first department, in the first department, they're the only jurisdiction that uses hearing panels as an intermediate step between the report of the referee and the matter being presented to the court. Does your organization have a view as to whether or not the hearing panel should
Generally speaking, we think the referee system is more efficient. We think it's more cost efficient for the respondent attorney. We think it would reduce some of the delays. I would say that we do see some value in the bifurcation of holding a two-stage hearing. But I think the referee system would look like it should work efficiently.
Thank you for your testimony. What are your views on opening up the disciplinary process?
We oppose it. In this age of the internet, well, let me say one thing. We do support the development of a central registry so that the public can go to one location and find the disciplinary history of every attorney. But that's only after it has been imposed by the appellate divisions. We do not support any earlier opening. I understand the issue of opening it at the point of charges, but I think on balance that does more harm than good. And frankly, if there is someone whose behavior is so bad that it needs immediate action, the appellate divisions have the power to suspend prior to the formal hearings, so the public can be protected without damaging the attorney's reputation until the attorney has had an opportunity to defend themselves.
Thank you very much.
Thank you.